everyone, and welcome to our webinar this evening on debt advice. Thank you all for joining. We understand financial difficulties can be overwhelming, but there are options and solutions available, and we're aiming to highlight and discuss those with you this evening. Our speaker today is Ronan Duffy. Ronan is one of the most experienced and highly regarded personal insolvency practitioners in the country. So we're in good hands, and so without further ado, I'll hand you over to Ronan.
Hello, good evening, everybody. It's funny what Damien said there, that there are options for people who get into debt in difficulties in Ireland. It does seem like it wasn't that long ago that there actually wasn't. And if I take you back to even 2007, so not that long ago, if you went, oh, sorry, it was 2006. If you went bankrupt in Ireland, you were literally one in a million. Okay. And when you compare that, with other jurisdictions about people who would go into a statutory insolvency procedure, wasn't one in a million. It's more like, one in 150 in perhaps in Scotland. I think in USA got down to about 175 at a stage there. So, that's comparing and contrasting jurisdictions is actually quite informative. I would say that debt is obviously incredibly difficult for those who are struggling with it, and it was long overdue that the government in Ireland brought about reforms to insolvency, and by insolvency I mean bankruptcy and the other statutory options that we now have that I'll come on to. Back in 2006 and 7, until the Act came, the Personal Insolvency Act came in, actually, the insolvency or the bankruptcy regime in Ireland was very, very draconian. I actually always sort of compare it with it was actually more draconian than the bankruptcy regime that Genghis Khan had. Genghis Khan, the law that they had was called the Yasser, and his bankruptcy regime was more liberal than Ireland's up until the reforms came in a decade ago. Going to look at. Oh, sorry, I'm just trying to move this forward. Oh, yeah, sorry, here we go. The agenda for tonight is I'm going to discuss a little bit about the personal insolvency landscape. Look a little bit about at where we find ourselves as a country. And then I'll run through each of the debt solutions. And that's to say that there's 4 statutory solutions. Statutory because they're there of the will of the Oireachtas. So it just means that they're enshrined in law. And then we'll look at a couple of case studies and explore the role of the PIP. Now, I'm one of 4 PIPs that McCambridge Duffy have, and we'll look a little bit about that. I'll try and then wrap it up and give you an opportunity then to ask any questions that you'd like. Now, I think Damien has received some questions by email, but if you want to stick them on the chat, then by all means, please do. And I think one of my colleagues is also sort of monitoring our other social media, and we'll pick them up that way if need be. Okay, so hope that sort of fits your with what you thought you were going to get, but we're just trying to, as I say, help people try to navigate the personal insolvency landscape. They help navigate personal insolvency in Ireland. Right, just looking a little bit at first at the current landscape that we obviously find. Now, we have obviously moved on from 2008. If you recall, we had the crash and the property crash and the credit crunch. And it then took until 2012 until the Personal Insolvency Act was brought in. The first case under the Act was actually one of mine, and it was a debt settlement arrangement. Now, we had been previously working with the Law Reform Commission and sort of consulting on how the reforms might be brought in. And when the legislation came in, uh, I kind of a little bit embarrassed. I'll put my hands up here and kind of say I was kind of focused on the mechanics of it. I was focused on the how you could craft the documents that you need and how you bring them all together, and met with the individual who was struggling and assured him that it would be okay. We went through the process. And I remember actually we convened the meeting of creditors that was necessary in Dublin. We brought some cream buns to it. I seem to recall, and some of the creditors actually came at the cream buns and still rejected, but the case was successfully approved. And as I say, I'd been quite what I'm embarrassed about is that I was focused on the mechanics and focused on the bringing it all together and making it work, and I kind of maybe forgot about the sort of the human actually underneath and it all. And it was actually after the case was approved and it had been successfully running for a couple of months that the debtor wrote to me and sort of thanking McCambridge Duffy and thanking me for what we had done and highlighting that they had actually attempted self-harm because of their the debt issues that they were struggling with. So I kind of found that really humbling and a kind of a bit of a sort of slap across the chops that okay, that yes, the mechanics can be brought to or made to work and the act can be made to work, but in actual fact, there's somebody there who needs help, who needs a solution to their debt problems, and I kind of like resolved never to make sure I never forgot that again. The current landscape, though, has moved on. Obviously, the banks had tried a lot of. If I'm sort of being generous about it, it was delay and pray, where they were trying to hold the line that people didn't need that and just work with the banks, and they were basically hoping that the property prices would recover and they wouldn't have a whole lot of non-performing loans on the book where it was in negative equity. But obviously we were well aware from, through COVID, through the global energy crisis and the cost of living, that the cost of living has ramped up and the higher interest rates have led to, a different set of financial pressures perhaps than we encountered in 2012, 2013, 2014. But that said, back then it was new and it was kind of people weren't really aware of it. I think credit to the Insolvency Service Ireland, they have sort of stuck to their guns, plugging away, trying to promote greater understanding that there is actually solutions out there. They're back on track scheme and so forth, and they've tried to improve access to PIPs such as myself and my Cambridge Duffy colleagues by through the Awalia scheme, which allows a debtor to get a voucher that they can then sort of see a PIP and get the appropriate advice that they need. Against that backdrop as well, we've had a shift in I guess the second, what I'm going to term the secondary market, and it's like where a lot of the banks have been packaging up and disposing of portfolios of mortgages. We've obviously had financial players who've left the market. We've had sort of the funds or if you like, or the vultures if you don't like them, come in and so that has changed. And I think from when you moved away from maybe some of the pillar banks to the funds actually generally have a preference for formal arrangements to restructure the debts, and and they're not averse to working with the debtors to make sure that they stay in the family home. Uh, so the legislation as well has changed a couple of times, and I think one of the early criticisms, if you like, was that the banks had a veto. Now, to me, that wasn't really an issue. We would kind of work with it and work around it, and it would, uh, the banks would ultimately end up accepting these arrangements just out of commercial sense. However, I do recall that myself and there was about four pips were invited to meet with Enda Kenny, and when he was Taoiseach, and sort of look at what could be done about the bank veto. And at that stage, they did tweak the legislation. They introduced what's called a Section 115A. So it's not unique in globally. I believe the Netherlands have a similar kind of approach, whereby a proposal is put to creditors, and the creditors don't accept, where effectively they reject it. You can put it before the court, and the court can then impose it upon the creditors and say, listen, guys, you made a mistake. This is it's good for you. It's good for the debtor, and impose it on it. So that tweak to the legislation was to try and remove the bank veto, but also to build up a body of if you like, of precedent, whereby things start to get accepted, and once the banks saw that the courts were prepared to take action and prepared to impose these, that they would start accepting similar types of cases. So it built up that what I've termed a body of precedent, which was pretty good. Okay, so all right. So hopefully this is an okay pace for you. Hopefully it's you're and hopefully it's interesting. Sorry, but if you have any questions, by all means, pop them in the chat or zap them to us. The most recent sort of central bank stats report highlighted that there's a significant number of mortgage accounts still in arrears. However, it's the peaked in 2013. So we're actually at the lowest level since 2013. But there's still a significant issue. It's still a significant amount of mortgages, where you have almost 30,000 mortgage on the principal private residence, or the PDH, that is are in arrears. And so it's important that there is something there that can be done for the debtor. Quite often for the borrowers. Quite often, the banks look to, when they get it in arrears, they were looking to sort of, in their credit, they were looking to work with them, but sometimes the solutions that they came up with were again, feeding into what I termed the delay and pray, and that was where they're warehousing significant chunks of debt. And then those warehouse arrangements, the duration runs out. They come out of so they've actually just delayed the problem rather than perhaps addressing it. But that, from a bank's perspective, the bank are saying, well, over that time of the warehouse, the property prices have so everybody's in a better position. And you're kind of going, well, not entirely true, but one thing that is very interesting, that of the accounts that are in arrears, we've seen a constant increase in the those that are held by non-banks, those that are held by the funds. So of that sort of 28,000, over 60% are now held with the funds. And if you go back a year ago, that was only 55,000. So that still is going that way, and I don't think it's going to show any signs of abating. The reason being is the banks have to prepare for the Basel III Capital Accord, which kind of punishes them if they have non-performing mortgages on their books. So they've all looked to package it up and get shot of their problem cases, and you'll see there as well. We said that in Q2 of this year, we had 32 PPRs or PDHs were repossessed, and obviously there's a substantial number of cases dragging on, and it's that really where you're trying to avoid. Okay, so there's, as I said before, there's four statutory options, and those are there by the will of the Oireachtas. Those options are bankruptcy, they are a PIA, personal insolvency arrangement, DSA, a debt settlement arrangement, or a debt relief notice, depending on the circumstances that the debtor finds themselves in, depending on their the level of their debts, depending on their income situation, depending on any assets, depending on the nature of those assets, will determine which is the appropriate solution. Now, it may be that they can linger on and do nothing, but at the same time, these options are available for individuals, so they may as well avail of them, if they can. A debt relief notice basically deals with unsecured debts up to 35,000. Now, when I say unsecured debts, that's typically credit cards, personal loans, perhaps overdrafts. It's not mortgages because they're secured. It's only unsecured liabilities, and it basically is a 3-year supervision, 3-year period of an arrangement whereby you say, listen, these are the extent of my debts. These are the extent I have less than €60 a month disposable income. That's after all my my expenses. So my income coming in, and then whatever expenses are to come off, rent and so forth, and then I have at the end of the month, I have after my reasonable living expenses, the after my reasonable living expenses, we have only €60, and therefore we can avail of a debt relief notice. Now, their circumstances are examined over the 3-year period, but no creditors can take any action during that period. Sorry, I should also say that they're allowed to have assets of modest value, including a car up to 5,000. Sorry, apologies. And they, after a 3-year period, their debts are written off. Okay, so it's not going to be suitable for everybody because they may have assets, they may have a disposable income, they may have more than 35,000 of liabilities, but it's that it is a bit of it is there, and is a kind of, I shall say this, is a bankruptcy light situation. Now, by that I mean it is a statutory procedure, but it's actually you in the first instance you would have to go to an approved intermediary, like MABS, like all of them, all of the statutory solutions. Your name would be kept on a register of DRNs, and that is but that's the same as the other solutions as well. Debt settlement arrangement is it's almost akin to the IVAs in the UK, but it's got a couple of sort of tweaks. The first case under the legislation that I mentioned before was a debt settlement arrangement, and by that it didn't deal with the mortgage situation, and in that one there was no mortgage. Um, so it's a legal agreement whereby you would propose generally over a 5 year period to pay contributions and to, so effectively you'd say, look, here's my income, here's my reasonable living expenses, and perhaps any special circumstances, and I can afford maybe 250 euro or 400 euro, whatever it is, every month for 60 months. Now, to be eligible, you have to be insolvent and unable to pay your debts. You generally have to have something to offer to creditors, so you have to have some sort of disposable income. Now, it doesn't necessarily have to be disposable income. Perhaps you have an asset, an unencumbered asset that you could dispose of. Perhaps it's a car, or perhaps it's quite often third party funds are used. So, you might have your uncle John or your aunt Mary or your the bank of mum and dad or whoever prepared to give you a lump sum to help address your creditors. And that's actually, and wouldn't typically then be a 5 year arrangement. That would be it would tend to be a sort of 1 year arrangement, but you'd be in and out quicker than that probably. So a DSA, like a PIA, isn't that you would go to MAMS in the first instance. You'd have to meet with a personal insolvency practitioner, like myself or one of my colleagues. Other PIPs are available, but you'd meet with them. They assess your circumstances and determine, okay, you don't have a mortgage, a problem with your mortgage. You have a problem with your unsecured liabilities, and this is why we would look at putting forward that kind of solution. The first things then the PIP would look to do is to apply for what's called a protective certificate. That protective certificate would give you then 70 days protection, during which time your PIP would work with you to draft a sensible proposal, one that's fit for purpose, that it's feasible, and it's fair to you and fair to your creditors. And they would then look to convene a meeting of creditors. Now, these don't happen with cream buns anymore. That was just the first one. They typically have they happen effectively virtually by email and by post. But as a debtor, you're not expected to attend your meeting. I know the credit unions are quite fond of trying to attend, but typically it would just be the PIP sitting in the room with the credit union discussing the issue. So certainly the pillar banks would not be, and credit card companies would not be, turning up at any of these meetings. It's One thing is actually quite interesting. Is actually interesting for insolvency nerds, perhaps, is that the equivalent, as I said, in the UK is an IVA, but it has a 75% threshold for voting creditors to pass. In Ireland, we have 65% of your creditors who vote have to accept the arrangement. But basically, what it is it allows you to prioritize your mortgage or your rent, prioritize your HP payments, so that you get to retain your car, so you can continue to work, etc., and do things for the family and the kids. But it allows you to retain these assets and deals with a problem unsecured issue. Those liabilities, and that's actually not a bad solution for many people. The personal insolvency arrangement, a PIA. No, it's not unique globally as in insolvency regimes, but it's pretty damn unique actually in particularly in Europe. And basically what it looks at is not only are your unsecured debts dealt with, but also your secured debts. And obviously in Ireland we had a problem with we saw the stats. You had a problem with the mortgage debt. So this puts together a structured arrangement to deal with typically over a 6 year period. No, sorry, that could be over a 6 year period. Most of them are actually about less than a year. But I'll come on to that. Again, you have to be insolvent, but you have to be able to, fund something against and by something reasonable against the mortgage. Again, you have to meet with the PIP. You have to again prepare what's called a prescribed financial statement. Again, you have to apply for a protective certificate, and that gives you that 70 days protection, during which your meeting of creditors will take place, and your proposals will be put to creditors. Now, quite often the creditors, they'll come back and forth, and they might sort of say, okay, we'll accept it if you tweak it this way or whatever. But say they reject. If they do reject, you have that what I referred to earlier, the section 115A, which is a mechanism whereby, subject to some criteria, that you can put it before the courts and have that solution imposed upon the bank, or sorry, well, the fund generally, But the so, but again, it's got that 65% of voting creditors need to accept, and then there's a second vote where it's 50% for secured creditors, 50% for unsecured creditors. So PIA is possible even when the repossession proceedings are at a fairly advanced stage. You can generally sort of draw a temporary halt to see if something can be hammered out. And the entire focus of it is trying to keep the debtors in the family home. Now, and we have done cases where people are prepared to give up their family home and downsize or whatever, or do something different. But that's is possible as well. But the primary focus is to keep people within the family home and get them returned to solvency as quickly as they can. Okay, hopefully that's where we're halfway through. So hopefully the pace is okay. And as I say, if you have any questions, we'll allow some time at the end. But if you have any questions in the meantime, you can bash them over, and I'll try and address them at an appropriate time. Now, bankruptcy is as I said, it's been with us since 1571, and where sort of post partition, the UK regime sort of changed, dramatically. Ireland, didn't really change. It was very, very draconian regime, but now, thankfully, it's been reformed twice, so that it's a legal process. But similar to other jurisdictions, bankruptcy is a court-driven, mechanistic process to get your assets in, realize them for your creditors, and make distributions to those creditors. If you have no assets, then there's no way of there's nothing then effectively there to distribute. You have to have liabilities of 20,000 euro or more, and similar in a way to PIA and the DSA. You have to meet with a PIP, because a PIP has to give you a report to say, listen, PIA or DSA are not viable options. Or if you've had a previous previous proposal rejected by your creditors, you can put that to the court. It's through the High Court rather than the circuit courts, and But what happens is from the day the gavel is dropped and you're bankrupt for a period of 12 months. Now, um, provided you're cooperative with the official assignee, provided you meet with them when required and provide them with any information that they require, then you'll be automatically discharged at the end of that 12 months. They if you've been sort of rash or hazard, indulged in rash or hazardous speculation, or you've been fraudulent or culpable or negligent in contributing to your bankruptcy, or you don't cooperate with the official assignee, they can look to have your bankruptcy extended beyond that. One thing is though, if you have disposable income, so say you had in a case where you had €200 uh, a month after your income is then deducted from the reasonable living expenses, and they assess that you have €200. Say, for instance, you'd assess that you had €200, and you put forward a proposal to creditors for a DSA, and then the creditors rejected that proposal. The official assignee would say, well, you can afford €200. I agree with that. What we want you to do is pay it into your bankruptcy for 36 months. So for a 3-year period, they want you to pay into that. Like the other insolvency solutions, bankruptcy is now a viable solution, and it shouldn't have the fear that it instill the fear that it once did. It's not a 12-year period; it's a 12 months, which seems entirely more reasonable. Which seems entirely more akin to other sort of OECD countries. That came out where you're looking to give a debtor a fresh start, not have them in sort of effectively in financial chains for 12 years. So bankruptcy is a viable option for very many people, and but what I would say is that if you have a mortgage, the bankruptcy doesn't deal with your mortgage debt. A PIA will deal with a holistic solution for your secured and unsecured. Bankruptcy will deal with your unsecured liabilities, and you'll still have to come to some sort of agreement or deal with your mortgage provider if you've built up arrears on that. So that's again an interesting one. But like I say, it's plenty people go through bankruptcy and remain in their family homes. Say for instance, there's a small amount of equity, then you'll have to do some sort of deal with the official assignee on it. But that's generally they're generally amenable to doing just that. So bankruptcy is, as I say, a viable option for very many people. Okay, I've got a couple of case studies here that I want to go through. I want to look at this case study with regards to a debt settlement arrangement. Peter was 48. He's a driver, married with 2 kids, and they rented their family home. He had approximately 65,000 of debts. Now that was over credit cards. He had a small overdraft, and he had a personal loan that he'd taken out in an effort to consolidate things. He injured his leg and was then unable to drive, and therefore was out of work. But with rent increasing, cost of living increases, it impacted his ability to get back on his feet. Now that's not a pun because he injured his leg, by the way. So he met with ourselves. We assessed his circumstances and said, listen, you're back working, you're able to, that's your income, that's your reasonable living expenses. So there's your rent, and then your reasonable living expenses, given the composition of that household, that he had 2 children, given the age of the children, and so forth. It was reasonable that he could afford €300 at the end of the month. Now that it's reasonable living expenses. It's not supposed to be. Well, I think I said on Joe Duffy once, it's not supposed to be a beans and toast diet, but at the same time, it's reasonable living expenses. So it's reasonable for, and those are published by those are worked on by the Insolvency Partnership and published by the ISI. But it's again, that's something that Ireland did really, really well compared to other jurisdictions. Other jurisdictions, the creditors impose what they think is reasonable, whereas in Ireland we had, an independent third party, a charity, work up what was the reasonable living expenses. In this case, Pete had his BSA approved by the majority of creditors, and he got back to sorry, again, I was going to say, got back on his feet. That's, sorry, no pun intended. Okay, so that's a DSA. PIA. PIAs are, as I said, are personal insolvency arrangement looking to deal with the mortgage and the unsecured liabilities. In this case, we had Patrick and Louise, two young children. Their mortgage debt was 370,000, but the property was only worth 250,000. They also had an additional credit card of the debts of 30,000. It also involved a credit union there. They had fairly decent household income, but with the cost of living, the mortgage rate was increased by the fund, and they had a hard core of historical arrears that they never got, that they never really addressed. So they met with the PIP, and we sort of worked it, verified what their income was, verified their circumstances, and pulled together a proposal, a prescribed financial statement, apply for a protective certificate, and then put it together a proposal to creditors whereby we said, look, we're going to restructure the mortgage payment. And in this case, we actually had, there was a couple of things that we brought to bear. Not only did we included a write-off. Now, what was sustainable was we wrote it off to market value. Just so happened it was written off to market value. And the balance then becomes unsecured in the arrangement, but we also needed to tweak the interest rate. The interest rate had gone up and up and up, and we put in place an interest rate of 3%. So the mortgage was restructured, and you can do a variety of things. You can restructure the term. You can have interest only. You can have partial. You could have but capitalize the arrears in this one and reduce the rate. In that one, the creditor, mortgage lender, was a fund, and they accepted that it was a PIA that was worth voting for, and the creditor thought it was a fair and realistic proposal. And Patrick and Louise got their arrangement in place, and it was got back on their feet relatively quickly. Sorry. I'm being told that there's questions somewhere. Oh, right. Okay. I believe outstanding debt at the end of the PA will only be written off if you're negative equity. No, that's not at the this outset of the arrangement. You put together how it's going to be restructured, but what we're actually saying is you can only ever write it down to market value. You can't, So what you're saying is if you're in negative equity, any debt that is written off will only be sort of that negative equity portion. However, the mortgage itself will be restructured to whatever is affordable. And that is how you address that. Okay, sorry, I'm divorced, but myself and my ex-husband cannot take over the mortgage from my ex because it's with Pepper. I had a arrangement put in place 3 years ago, 3%. Go back up to 6 and back in arrears. Right. It's you can do a PIA without an X. There's a quite uh, an important case that went to the courts that was that that you can do it with just with your where it's in sort of circumstances like this. We had quite a lot of cases where sort of one party sort of left the matrimonial home, went abroad or wherever, and then somebody stuck with a situation that they're not really of their making, that they're trying to address. Um, you'd need to sort of explore that a bit. Sorry, that actually worthwhile. That case was one of ours. It was sort of pretty groundbreaking at the time. Surname, the name of the case is actually escaping me, but I'll come back to it if I remember. The uh, the but you probably in that circumstances you need to meet with a PIP, and then you can definitely do a PIA without your ex. All right, Damien would like to answer this question. Oh, by all means. All right, go on ahead, Damien.
Thank you, Ron. No, no, yeah, no, it is possible. We do it quite often, so we do. Unfortunately, separation is an insolvency trigger that we would see quite a lot in cases. Um, the creditors would have asked for the co-borrower, the party or partner or party to the mortgage to be involved in the process. And as Ronan said, that judgment, that High Court judgment, basically ruled that wasn't the case. Someone can be assessed based on the fact that the family home that they're living in, they're the person who's residing there. They're liable for the mortgage, and they can bring a PAA proposal. So being assessed to see if that was an option to restructure the debt would be advisable. Yeah.
With regards to the question on the tax, there are provisions within the capital acquisition tax to allow for sort of third parties to provide funds for that are not then subject to that. Looking back down at the very bottom where we say that can you exit a PI before it's ended if you make a deal to pay off your creditors? Quite often when an arrangement is put in place, be it a PIA or a DSA, something might happen. So life still goes on. If you've entered into an arrangement for a period of 5 years, something may happen in the interim period. You may lose your job. You might or you may have a relationship breakup or whatever it is. You can put forward what's termed a variation and get that accepted by your creditors. Now, what you're alluding to there is if your circumstances change positively, that you could actually then reach an early premature settlement on it. Then that's absolutely fine, in that you can put forward a variation to do what we would term a full and final. So that's no problem at all. There's a question then on the cost of the mortgage was KPC sold their mortgage to, and I now have to pay that. That's sort of is right up the street of what we're talking about. And I suggest that you would see a PIP on those to try and determine what is the way forward. Guarantor on the loan with the legal loans. Guarantors again is a fairly hot topic. Is that but what those type of loans where there is a guarantor, they will look to pursue the guarantor in respect of that liability. We have structured arrangements in place where by that there's effectively a repayment to the guarantor, so that effectively they become a creditor, because they've guaranteed a subrogated creditor in that instance. So yeah, again, it is a hot topic. It is a live issue. This was a case of no, this is actually one of mine, and it was a difficult case. I'll say that at the outset. the I wouldn't have actually thought at the outset of doing it, doing it this way. But tricky cases often come up with then spectacular solutions. Those spectacular solutions, then people are, that's what they all want, but it depends on your individual circumstances. So that case, was, as I said, it was tricky. She was a PA. She was 60. She was a mother of one, but she was separated, and the house was had PPR value of 420,000. Compared to the debt of 240, but we needed to restructure it in such a way so we reduced the rate right down and fixed it for 17 years. Now it was rejected by the fund, but we put it forward to under a section 115A, and effectively it was imposed on the creditor. Now I was delighted, obviously, for Helen. I was delighted that we got the case across the line, but I was slightly wary that that people might think, oh well, that's what I want. It depends on their individual circumstances. So your PIP is going to put together something that is affordable for you, and depending on your level of income, your level of liabilities, and so forth, that is dependent on your circumstances. The previous lowest rate was 2.5%. And the fact it was 0.5% for 17 years, I would be sort of slightly wary about people going, that's what I want, because it, as I say, it depends on your individual circumstances. But what I do think that was important about is that 60, I'm going to say, is that if we're looking for that fix is out to 77. So we do have a problem in Ireland regarding aged debtors, that cohort of older people, and most lenders are now prepared to look out at solutions that get to 80, but we've had a number of them approved beyond retirement until 90 plus. You're talking about some sort of lifetime tenure type restructure, but it depends on the circumstances. But I'm starting to see a bit of hope about for those aged debtors, that cohort of aged debtors. Sorry, is there more questions there that I missed? Good evening. I'd like to know what a PIP consultation is. Free consultation. Initial consultation, there's no upfront fee, and then your fees are typically built into the proposal, so that they're extracted from your monthly contributions or whatever lump sum goes to creditors. So you don't actually get, you don't really get a separate bill from the PIP. Now, I did say about the Awalia scheme as well, that the Awalia scheme permits you a voucher to actually go meet with the PIP. So that's is useful as well. I think I've only got. I might come back to these two if you don't mind. I'm going to just look at the role of the PIP is sorry, when I on that one is just trying to work with someone to assess what the financial situation is, to evaluate what's the right solution. So you meet with the PIP, and maybe it is bankruptcy, and the PIP will give you a report that you can petition the court then for your bankruptcy. Maybe it's a DRN, and they'll signpost you to to MABS as an approved intermediary. But if it's a DSA or a PIA, then the PIP will work with you on that. But it's good that you get your options explored. It's good that you get your options explained to you. And it may be that you decide, look, to be honest, I think I can probably cut back here, or maybe get a bit of assistance from somebody else, or mum and dad, or whatever it is. Then that's fine. But if you can't, then there's the PIP will work with you to determine what's the best way forward. So they draft a proposal. Once the PIP reviews it and they're happy, they pass it to you. Once you review it and you're happy and you understand it, ask any questions on it, then they would convene a meeting of creditors to put it forward to your creditors. And then, at that stage, once you go into protected certificate, none of your creditors can contact you. And if you come out the other side with an approved arrangement, your creditors never contact you again. So effectively, unless it's a mortgage, in which case, they'll have their usual sort of dealings with you. But if, other than that, the PIP looks to secure arrangement, secure an agreement of your creditors, and then resolve any disputes. And the PIP will have to, if you enter into an arrangement the last 5 years or 6 years or whatever, even if it's a 12-month arrangement, the PIP has to make sure you stick to your side of the bargain. So they'll effectively supervise you, doing what you said you would do. Okay. In summary, I'm coming up here with Damon, you can correct me if I'm wrong. I was 7 o'clock, right? It was 7. Okay,
Yes.
all right. Sorry. I thought you were going to spring it on me. No, it's 7:30. You can talk for another. But no, fortunately, you don't have to. But we're quite sort of keen at the Cambridge stuff. We do understand that financial problems are, terrible. Financial problems often follow you around like a cloud. When you get into bed at night and flick off the light, they're there. When you wake up in the morning, they're there. So, but every debt problem has a financial solution. And that's really what we're as PIPs, what we're looking to do is work with people and explain, and signpost them. It may be that we, that the solution is petition for bankruptcy. We'll explain to you what that means. We'll explain the implications, the ramifications, and then you can as a debtor, can make an informed choice and say, yeah, do you know what? Bankruptcy's for me, or I want to put forward a DSA. Whatever it is, they'll work with you in that respect. Okay, so I'm just going to there's a couple of questions come back in, and I'm going to work through them. Right. Okay, sorry. I'll just deal with this one at the bottom. So I'm working back up with them, I think. So should I sign my car over to a family member when a finance ends, so it won't be taken away as an asset against other outstanding loans? That what you're looking to do there is in effect, you're looking to take an asset and put it beyond creditor reach. That would actually invalidate you for, or make you ineligible rather for putting forward a proposal. Where you have a vehicle, creditors accept that you need a vehicle of a reasonable, size, standard, whatever, to for your family circumstances, to get to and from work, to get the kids from school and activities and so forth. And if you look to put an asset beyond creditor reach, then and we have experienced it in the past. All you're doing is making yourself ineligible for any of the solutions. So it's better to to work with your creditors to come up with work with the PIP to come up with a solution. So I wouldn't be doing that one. What can happen in Ireland if you ignore paying a loan you can't afford? Does it go to court? It depends. It's then if you just don't if you do nothing, it's then down to the creditor to determine what is their preferred course of action. If you have sufficient liabilities, that they could look to bankrupt you. It could be that they just engage the services of collection agents and plague the life out of you. But what I would typically say is that even if you're not considering, maybe you have a loan that is of a level that it's too low to put forward petition for bankruptcy, it's considered a DRO. But what you might actually think about doing is actually just engaging with your creditors and explaining your circumstances and asking them to would they consider giving you some sort of forbearance or writing it off. Typically the do nothing approach does not work. No, there's a good question, by the way. It seems like the like the legislation only works for high profile property developers and millionaires. Does it work for the ordinary person? Absolutely. We have done cases in every county in Ireland. We have done cases for, most professions, most types of, from barristers to bricklayers. We've done those types of cases. And why you're saying about high profile, the reason those kind of stick out in people's head is because the media have actually been pretty good about not, naming anybody. But if it's a high profile case, if it's a high profile individual, if there is a public interest that they perceive there to be a public interest, they will go ahead and name them. That's why, you think that it only works for property developers and millionaires. That individual who did the first case, he worked for the HSE. He was paranoid that because it was the first case, that his name was going to be out there. Fairness to the media, they didn't name him. They were in court, so they knew his name. They didn't name him, and but he told me a story that his next door neighbor came around with a copy of the newspaper and said, would you look at this, lucky excuse my language, he works in the HSE just like you. He's the same age as you, and he went through the whole rigmarole, but never put two and two together that it was the person in front of him. So the legislation definitely works for ordinary people. The reason there's a perception that it only works for the property developers and so forth is that those are the cases that attract media attention. Okay. Okay. There's a question there. Recently in a financial position to pay the full mortgage repayment, you have arrears also separated, and the divorce is in process, and the house is on family land. The fact that you're now paying, people, you're no way to address the arrears, but it may be in that situation, it may be that the lender would be prepared to capitalize their arrears. It may be that they would prepare to offer you a solution on that. The fact that you're paying actually augurs well. We quite often have people approach us who say, "Oh, I've been, I was told by a guy in the bar to stop paying my mortgage," and you're just kind of going, "Right, for the love of God, why?" And they said, "Oh, he said I was going to force a deal out of the bank," and that's just nonsense. Because if you want to go through the process, you have to demonstrate some level of affordability. You have to demonstrate some willingness to put your best foot forward, and you have to demonstrate to the if you're going to go down the section 115A, so if somebody comes to us and they're not paying, the first thing you will do is figure out what they should be paying and get them to start paying that. Because if it ever comes to maybe the creditors reject it and we put it before the courts, by the time it comes in front of the judge, it's actually they have a payment history. So it demonstrates to the court that that's actually sustainable because they've paid 12 months worth, or they've paid 18 months worth, whatever it is. So I'd be very, very wary of cases where people say, "Oh, I'm going to stop paying to try and extract a deal." In your circumstances, now I appreciate it that you're going through quite a lot because you've got the divorce as well as the arrears. The fact that the house is on family land and stuff, doesn't help either. Doesn't help you in terms of the worry. But if you're in a position to pay the mortgage in full, start doing that. And in that circumstance, I would generally approach the lender to say, "Listen, my circumstances have now improved, but what are we going to do with the arrears?" If they don't play ball with you, then see a PIP, and the PIP will sort of manage to get something. Now the arrears you've said are 30,000. If you have others, liabilities, then certainly something that could be done there. But by all means, in that one, it may be that you could ask the mortgage lender what they think first off, and then take it from there. Okay, so sorry, I have 2 questions here. I'm sorry. They look like slightly more complicated questions. That's why I left them for then. Yeah, unemployed, 2 children, just started university, large amount of arrears, mortgage, monthly payment from Uh, is more than I get per month. The house is in positive equity, probably 200,000. The house sold. Go to my eldest two children. This is left in a will. This pays off the mortgage, leaves us homeless. Oh, no. Well, okay, yeah, I appreciate the circumstances. It's that's a tricky one. Um, but obviously it's complicated by the arrears position, and it's complicated by the existence of the will that deems that it's left to your older children. Um, so what I would suggest is just trying to hammer that out and explore. Pepper, they're not the worst. We find, they can be tricky sometimes, but they're not the worst. So I would sort of reach out to a PIP to try and nail down what can be done going forward. Obviously, you've just started university. You have a university. You've got a horizon ahead of you before you look to do something. But I would certainly explore with a PIP what might be your options. Okay, so refused by mortgage to rent scheme due to the high cost of repairs to bring the home up. The council circumstances, ill health, and children of special need, child with special needs, rather. Um, hmm, yeah, no, it's we you again, it's probably one that you need to thrash out um, uh, with a PIP, thrash it out, trying to determine, with the fund, what might work, what might not, and but you're saying that the property is valued at at near what's owed, but it certainly it's worth something that exploring. The special circumstances around the health and the child with special needs, again, they can be factored into any PIA. One thing to point out is that the mortgage to rent scheme has been rebooted, so it might be. I don't know how long ago it was. You got it turned down, but it's actually something that you might be able to explore with your PIP. Okay, I actually have. I think, is there any more questions, gents? Is there,
We,
Damien?
we have we have one question that was received to Facebook as well, Ronan.
Yeah.
Here. It was, what about the new EU Directive Article 28 forbearance?
Um, okay. Again, this is kind of there's obviously as EU members we have to follow what comes out of Brussels, but the banks also have to follow what comes out of the Bank of International Settlements that was alluded to as the Basel III Capital Accord. And there's a lot of what is in Article 28 of the EU Credit Directive, or sorry, Mortgage Credit Directive, rather, that is uh, kind of brings in line with the sort of the Basel III Capital Accord. And yes, I'm sure pretty much our banks and our funds would argue that they're already engaging in forbearance, and I think that can actually probably borne out by the stats, to be honest. Um, but there's it also allows for transparency, greater transparency around that the solutions. Um, you can be rest assured that the Department of Justice and the ISI and the central bank are looking at the Article 28 on that. They're looking at the whole of the Mortgage Credit Directive to try and make sure that the legislation and the central bank guidance and is all in line with what's coming out of Brussels. But like I say, the banks argue that they're already there because of what they've been doing around the Basel III Capital Accord. So, um, I think the emphasis in all of it though is that my understanding is it's about fairness and transparency. Banks will be arguing that they're already there. Maybe not, but that's why we have the courts, and that's why we have the PIA Section 115A process that can also help. Connell or Damien, any other questions? Did I miss anything?
We have another one here. Just what happens at the end of a PIP? The end
The
of
end
a
of a PIP.
PIP.
I'm hoping to have a very good funeral and that sorry, do you mean end of a PIA?
End of a PA. Yeah, end of an
Right,
arrangement.
okay.
I'm assuming. Yeah.
Sorry, hopefully you're not. That's not a veiled threat, Tony. And I'm actually at the end of a PIA. What the PIP does is reviews to make sure that the everything that the debtor said that they would do has been adhered to. So perhaps there was a buy-to-let that had to be voluntarily surrendered, or perhaps there was contributions over the lifetime of the arrangement, and they get confirmation from the mortgage provider that they, not only have those the mortgage up to date, and then what they would look to do is prepare a final report, whereby you get a certificate of completion to say that you've been through that. They would notify the ISI, and the ISI update the register of PIAs, and then the debtor is kind of not like on their own, but like released back, and effectively they just have a normal sort of relationship then with their mortgage lender, and that has is how it works in practice. Hopefully that addresses your question, and it actually wasn't a veiled threat. Anything else?
Yeah, that's all the questions we've had tonight so far. Yeah.
Okay, well, hopefully you have found that to be useful. Hopefully you have found it that it's sort of cleared up sort of some issues, and it's like, to be honest, if I go back to where I started on the back to 2006, where somebody who going into a statutory insolvency in Ireland was one in a million. If you actually looked at that, we've got to a place now where there's 4 statutory solutions that are all used, and they're all well-worn paths. There's less stigma now around it, that process, and that is but that for debtors there is a solution out there. Depending on whatever their circumstances, there's a solution, and that should give you hope.
Great, thank you, Ronan. I think from some of the questions there too, there probably is a few people who've joined tonight that an assessment would be useful. We'll drop an email with some contact information, and if anyone wants to reach out and schedule a call next week, we can do that. That's not a problem. But I'd like to thank you all for joining our webinar tonight. And as I say, any follow-up questions or anything at all, just reach out to us, and we can definitely schedule a call with myself or Ronan, and do an assessment whenever would suit you. Okay, everyone, thank you very much.
Okay, thank you kindly.
Thank you. Good night.
Bye now.